Hi, concerned citizens of BC. I'm back with more injustice. Firstly, I would like the good people of Hope that came up front after seeing Liz sleeping in the town park in the rain in a very small tent with sleeping bags, food, and cash donated by compassionate and concerned citizens in Hope. The town of Hope let her sleep in the park for several nights and allowed her to sell her handmade native jewelry in front of the town office. No one in the 16 years I've lived here ever was allowed to do this. Camp in the park and the cops are there. But this time, Hope had compassion and they allowed it. The good people in Hope paid for motel rooms and gave her the funds to go back home to the island. WeAreChangeHope.org plastered posters from Yale, Hope, Chilliwack, Abbotsford, Vancouver, and Victoria, Hastings Street. This is the posters. This is the posters that we've plastered all over the country, and there's more to come. It worked the very next day. Liz got her driver's license back. The 90-day suspension was over in 15 days, and the good folks in Hope helped her get her mini home back. The power of a poster and video with no newspaper ads did it, and it's just starting. The ads are coming next. Liz sent me a picture of her back on the island at home with a thank you to the good people in Hope. This is the picture. This is the picture of the mini home that she got back, and we'd like to thank the people again, and I'd like to thank everyone that donated the money in Hope and their time and efforts and clothing. I'd also, again, let it be known that most judges, lawyers, and police act in good faith and abide by the rules of law. But for some, loyalty to the establishment and the love of power is more important than the truth to their own oaths, and accountable justice and democracy are put at risk. Thank you for the good judges and police officers. That's why I'm here and able to do this today. What we're doing today is we're concentrating on the Law Society and the corruption of the lawyers. And I'm going to start with the letter that I got when the corruption started, and I went to a court of no jurisdiction, and when the court of no jurisdiction started making unjust claims for themselves, I decided that we have to stop this. And there's only one way to stop this, and that's to give the truth to the people. Now, we're going to get into the lawyer and the Law Society. That's what we're doing today. Here's the transcript of trial from Comrade Gardner. Firstly, he states that in the pretrial conference, the settlement conference, the only order a judge can make in settlement conferences are orders that are made by consent. He states that in the proceedings of trial. Then he goes on to state that he has an exhibit from the court, exhibit number 1, the invoice and newspaper ad. Comrade Gardner and Comrade Miller simply had to look at the newspaper ad and find that everything was false. It was that simple. But then he goes on another page and he says, well, now at this point I have to tell you I can't award more than you claimed. You claimed $3,000. No, I understand that. All right, stated. And it goes on and on. It's full of perjury and false claims. So what I had to do was retain a lawyer. So I retained Jay Strafe after going to the Attorney General, because I sent the Honorable Susan Anton without prejudice. Please note, the attached documents give me a right to a collateral attack on judges that operate in our honorable courts in this manner. On February 22nd, 2013, I, Ken Olson, witnessed the Canadian judicial nightmare. My documents are prima facie and documented in BC's honorable courts. It was 9:30 a.m. at the Chilliwack, BC Courthouse, second floor, room 205. The serpent of injustice entered. His name is Gardner, and took his false throne. He is about to begin a treacherous act, actually the beginning of a nefarious plot. The Olsons and the Jordans are called forward. Olson advised the Serpent Gardner that he has no jurisdiction. Further, that his brother-in-law Miller, in the same jurisdiction without a fair hearing or any fundamental justice, has dismissed my counterclaim against a perjurious false claim. This is regarding a 38-year-old mobile home, 1974. Miller and Gardner had simply to look at the claim and look at the newspaper ad, and it's false, it's over. The Serpent, having been advised of my rights in his jurisdiction, commits the treacherous act. He did with dirty hands and full knowledge that an appeal was mandatory. He refused to wait for my application to the Attorney General and Justice Minister. He refused the mandatory 40 days appeal time and seized my bank account. The Serpent's acts are beginning. They're not over yet. The order given by the Serpent is an order of nullity. At law, it's called functus officio. It's worthless. The Serpent gave a 38-year warranty on a mobile home that the manufacturer gives a 1-year warranty. He must sit on some kind of a throne of oaths that Ken Olson doesn't understand. He states in his transcript, "I can't give you more than you asked for in your claim, $3,000. It is in the transcripts. The Serpent of Injustice makes a biased and treacherous precedent of law and awards the Jordans with the false claim $23,600 plus costs. It's going to come to thousands more. Mr. Olson walked out of the court after notifying Mr. Gardner of his rights. This is an ongoing living nightmare, not only for the Olsons, but for many citizens in British Columbia, especially in the district of Chilliwack, BC. Let's look at the attached documents in BC's honorable courts. False notice of claim. Reply to the claim is filed. Bill of sale, no warranties attached. Settlement conference, Miller. Looked at nothing. Notice of claim, Gardner. Settlement conference was a sham. Trial transcript, Gardner. Trial order, Gardner. Comparative mobile homes and the trailer ad. Most mobile homes that I sold for $13,500 are worth about $30,000, and I have all the documents. We won't get into that. I notified the Attorney General and Justice Minister. I received an answer from Acting Assistant Deputy Attorney General Jeffrey S. Morsey, QC. He states that he is responding on her behalf. We're going to read that letter. My answer to this letter is, Mr. Moisey states that he answers on your behalf regarding this prima facie documented issue and disrepute in our honorable courts of BC. He is aware of the order of nullity and the severe harassment that my wife and I have been subjected to. The Attorney General is aware that a court of no jurisdiction has aided and abetted the Jordans to commit fraud in excess of $20,000 with the aid of a Serpent in our honorable courts and the aid of a high-powered lawyer, Jay Straith. Mr. Moisey further states to hire another lawyer. I did this, and it's before the Board of the Law Society of BC pending a hearing. I also followed his letter acting on behalf of the Attorney General to present this information to the RCMP and Hope BC. The Hope BC RCMP viewed the Attorney General's letter and refused to view the documents regarding this issue. I was advised by the Hope RCMP that perjury and harassment they don't want to look at in Hope. They're too busy. Mr. Moisey in his letter states that both parties to a dispute are entitled to a decision made to an independent judiciary. He also states that the Attorney General has no role in reviewing specific decisions of the court. However, it must be noted, on rare occasions, and this is one of them, our courts are put into disrepute. When this occurs, the Attorney General's Act comes into effect. The Attorney General must act within the rules and law of BC. A request for a judicial review was denied, and all rights as protected by the Charter. I have now made a decision. Spend $25,000 going through BC's courts of disrepute, or spend 2-3 years and $25,000 for justice change. I, Ken Olson, chose change. That's why we are hopechange.org. With no results, I intend to file a class action against the Attorney General of BC and the Queen of England. I am not alone in our honourable courts. Our rules and laws in Canada are good rules and good laws, but they must be honoured by the Attorney General Susan Anton and our honourable courts to uphold democracy in Canada. I further would like to exercise my right to run for MLA for Chilliwack, Hope, BC, to expose this injustice in BC's honourable courts. I also took these very posters and taped them right on to the MLA Laurie's office in Chilliwack. More than once, and I got no reply, and I also posted these posters on the courthouse and I posted them on Mark Stahl, his office, front door and windows. Neither Mark Stahl, the MP in Chilliwack, or Laurie Thronis, the MLA, gave me a call or responded in any manner. So I've made a decision. I'm going to move forward, and I'm going to talk about the corruption in the in the Law Society. Here is the letter after giving all the documents of the criminal harassment I went through in this corrupt courts and all the documents I sent to the Attorney General. I got a letter back January 20th. Your box of documents received by the Attorney General and Minister of Justice of British Columbia on January 9th, 2014 has been forwarded to me for response on her behalf. I note your concerns regarding litigation in which you have been involved in British Columbia and Alberta. As I mentioned in my letter of April the 9th, 2013, it is not generally appropriate for the Attorney General and Minister of Justice to comment on private legal matters. Many people write to the Attorney General and Minister of Justice believing that she can intervene in their legal matters and bring about the outcome they would like to see, but that is not something she can do. It is the role of the judiciary to make decisions in legal disputes brought before the courts. Both parties to a dispute are entitled to a decision made by an independent judiciary. This also means that the Attorney General and Minister of Justice has no role in reviewing specific decisions of the court. Parties to litigation who are dissatisfied with the judicial ruling have the option of appealing that decision with certain time limits. Well, here I appealed one all the way to the Supreme Court of Canada, and all these documents, you know, I appealed right to the Supreme Court of Canada, document after document on a false claim, just like what's happening with Comrade Gardner and Comrade Miller. But to no avail, the Supreme Court of Canada, we're going to get into that. I'm going to read all about the lawyers of the Supreme Court of Canada because it's important, and I'd like you good people to listen. With respects to your concern about the Honourable Judge Miller and the Honourable Gardner of the Provincial Court of BC, I understand in your correspondence that you've contacted the Chief Judge and received a response from Jeannie Jamieson, Legal Officer, Office of the Chief Judge. Complaints about the conduct of a provincially appointed judge in the Provincial Court of British Columbia, as opposed to the correctness of his or her decision, may be brought to the attention of the Judicial Council of British Columbia. The Council is a body created by legislation whose object to improve the quality of judicial service. I note Mr. Jamieson's letter explained that the Chief Judge has no authority to examine complaints about the merits or correctness of a judge's decision. Well, it's on the back page because they're saving paper. You mentioned that you would like the right to lay in information against certain individuals for what you describe as wrongful acts in the courts. Whenever an individual has reason to believe that someone has been involved in criminal activity, the proper course of action is for that individual to report his or allegations to the police in the community where the alleged criminal activity occurred, as I understand you have done in the past. If the police determine that an investigation is warranted, they will conduct one. They are also in the best position to determine whether a particular allegation involves a criminal matter or if the allegation, if pursued, would have to be addressed through civil law. If the police determine that there is sufficient evidence to warrant a criminal charge, they will forward a report to Crown Counsel in the Criminal Justice Branch of this ministry, recommending that a charge be laid. Crown Counsel will review the report and decide whether the evidence will support the charge and whether a prosecution is in the public interest. The Attorney General and Justice Minister does not have a general mandate to intervene in this established process. Each component of the justice system is independent of the other in order to provide checks and balances within the system. You also mentioned that you have consulted a number of lawyers in the past. A lawyer in private practice would be able to advise you of your legal rights and options at this time. The role of the Attorney General and Minister of Justice does not extend to providing legal advice to members of the public. Contact information for some free legal resources and the lawyer referral service was included in my April 9th letter. I remain Jeffrey S. Moisey, QC. Now, I had to look at this, and this is a standard form letter. I mean, they just mail this out to everybody in BC that they think is stupid. Well, I'm not stupid. Juris ignorantia est cum jus nostrum ignoramus. When we are unfamiliar with our rights and ignorant of the law, no more. I'm totally familiar with our rights. And here's the letter I sent to them. Here's the letter I sent back to him. In reply to the letter from Jeffrey S. Morse, QC, the Acting Deputy Attorney General of British Columbia, dated January 20th, 2014. This response is for the BC Law Society and the BC Civil Liberties. In the letter received by me, Ken Olson, Jeffrey Morse states that it is not generally appropriate for the Attorney General to comment or act on private legal matters. Please note, this is outside of a private legal matter in our courts. When the courts are put into disrepute, hold no jurisdiction, and create an order of nullity, functus officio, for you learned friends, and use this very order to seize funds from my bank and give a person a warranty on a 38-year-old mobile home is far from generally. If the courts in Chilliwack, BC generally operate in this manner, then we all have a justice problem in BC. Justice Garner stated that the Justice Miller order had to be by consent in transcript. It wasn't. It was an error of law on the face of the record. I further do not want the Attorney General to intervene in my private legal matters. I want her to uphold the Attorney General's Act, namely the duties and powers on page 1, number 2B, and must see that the administration of public affairs is in accordance with the law in British Columbia. Fundamental fair justice was denied to Ken Olson in BC's honourable courts, and I want to make them honourable again, and that justice is the outcome I want to receive. The letter further states that that is something that the Attorney General cannot do. When the courts and laws and rules are prima facie in disrepute, it is the Attorney General's duty to correct it when fraud and harassment are an issue. Jeffrey Morse further states that both parties to a dispute are entitled to a decision made by an independent judiciary. In some rare cases, and this is one of them, the judiciary is not independent, and this is what happened in Comrade Miller's court. Comrade Miller, in dismissing my counterclaim, is giving the right to all false claimants who have no right to damages for their actions and perjurious claims. Comrade Gardner made an order of nullity, functus officio, based on bias and emotion, based on my complaint to the Attorney General, who failed to act and is generally not appropriate, or they just don't want to look. The letter also states that I can appeal the decision. I appealed a false claim with no jurisdiction to the Supreme Court of Canada. The cost is not just. It is more than $25,000 to get to Ottawa, which I made very clear. In my communication to the Attorney General, I included 33 files of the RCM police showing false arrests, beatings, and threats on my life more than once. The Hope RCMP has also laid false charges. I had to contact the Transport Minister to stop. Now I'm told to go to the police by Moisey. I'm a blue card, which most of you don't know what is, but the police do. And that cannot be done. It is stated that the police will look at my information and give it to Crown Counsel. I still want the right to lay an information against Cheyenne and Jamie Jordan. My letter stated that I had retained my last lawyer, Jay Straith. He is still holding $12,330.50 of my money in trust for want of an order to pay the Jordans on the order of nullity and return the mobile home. It has been over 10 months and nothing has been done by Mr. Straith. On January 22nd, 2014, I requested the return of my money in his trust account and told him I'm taking a fresh step. Mr. Straith received the email concerning the money and replied shortly that day and answered that he would get it organized. As of yet, again, nothing. I want my money back. It is 2014, and in order to sue BC Justice and the Attorney General, I have to sue the Queen, whose kingdom brought this outdated system to Canada on a boat. I'm Ken Olson. This bullshit is going to stop. Now, we're going to get right into the Law Society. All the legal reasons to justify. And I'm just going to show the judicial misconduct, conduct of a judge that is so manifestly and profoundly destructive of the concept of the impartiality, integrity, and independence of the judicial role, that public confidence would be sufficiently undermined to render the judge incapable of executing the judicial office. Report to the Canadian Judicial Council. It's It's a miscarriage of justice. It's prejudice. There's a reasonable apprehension of the bias test. There's an error of law in the face of the record. And I don't have to get into all that, but when we look, when jurisdiction is in question, a collateral attack is a right. Comrade Miller, Comrade Gardner, listen, it's got to stop. I have a right to a collateral attack, and I have a right to call you two guys comrades, because this is kind of a socialist communist act going on. An abusive process is a term used to describe an improper use of the judicial proceedings and may arise if jurisdiction were exceeded. It arises when a legal process with some legitimacy is used for some ulterior motive other than that for which it was intended. It is invoked to protect against harassment, and that's what happened to my wife and I, or the perversion of the process accomplish an improper result. According to the Honorable Gene Crescian, and I had many around with him, we have the occasion to build for our children and the children of our children a better Canada, a Canada which will recognize the diversity and equality which should be our society, a Canada which will protect the weakest in society, a Canada which will be an example to the world. It's all bullshit. Now, let's get into the Law Society stuff. The Law Society. Firstly, after retaining Jay Straith, and on May 29th, after 3 months of waiting him to file something and nothing was done, I sent him this notice. Attention, Jay Straith. Please be advised that I, Ken Olson, do not want to file an appeal on Gardner's decision of February 22nd, 2013. I want an order to have the mobile home returned to me, as the money they seized and the money in your trust account covers their request and the statement of claim. I also would ask that this be done in a timely manner, as I am unable to deal at my bank with this false claim in force. The Law Society got a copy of this. Anything that I gave to the Law Society is not to be kept secret, you guys. What I tell you guys is not a secret, and I'll keep what you told me a secret till we get there. Now here's Jay Straith's bill for $1,411. It says for professional services. Here's a notice of payment paid into the court by guarantee, April the 10th, 2013. Jay Straith's holding the money in trust and their seat. He doesn't tell anybody he's got it. So you know what? The bills start coming. Here's one after they seize the bank account. Now this time it's starting to add up. First it's $13,367, but by the time this guy gets through roaming around, it's $15,510. They seize that too. Here's my bank, subject of a third-party note. Now they want $24,142 at our bank. They already took everything else. Well, when I got a hold of the Law Society and gave them all the information of this corruption, the very next day, Jay Straith sent me this check. I drove all the way to Vancouver to certify it because, I'll be honest, I didn't trust him. There are many good lawyers, but I didn't trust him. So I drove there, and that's another expense. March 28th, I had the money in the RSPCs. This check was given out after that date. I got that, but $1,400 worth of bullshit for professional services I didn't receive. And it says right here, expense, our fees for professional services. I mean, when we look at that, in the account with Jay Straith, though, that's the biggest thing on the page. It should be the professional services. Professional services, I advised and showed them the documents. I brought the Supreme Court applications over a lawyer doing the very same thing as Jay Straith's doing. I gave this to the Law Society, and we're going to speak about that, and we're going to speak about why we have to stop these corrupt lawyers. And we need you good lawyers to help us, because if you don't help us, this jokes of lawyers will go on forever. This is an introduction to a part only of prima facie documents relating to the upcoming independent public inquiry and gathering of documents for all Canadians. The most important words in the world are peace, justice, oath, truth, accountable, and democracy. There is no peace without the others. Nothing exists without all of the above as one. In Canada, we prima facie have failed. The following documented facts show that in Canada, our justice and truth are denied to many with accountability to no one. If justice, oaths, truth, and accountability are denied to Canadians, we all fail in peace for the world. What message are we sending to our youth? We send our soldiers to far-off lands to fight and die for a democracy that some think can be bought at home, and some do just that. Injustice is beyond out of hand. It is just us. Democracy is only a word without justice, oaths, truth, and accountability, and honorable courts and boards. No one is accountable in Canada. This includes RCMP, police officers, justices of the peace, prosecutors, lawyers, masters of the court, judges of the court, boards of the court, the Supreme Court of Canada. And we'll get on with it. I took this to the RCMP before I get into the Law Society, as per the letter of Moisey and James Straith. It says, to whom it may concern, read James Straith and the RCMP Hope. A new nightmare. If Jay Straith had done his job, this nightmare couldn't have happened. On Wednesday, March 19th, 2014, as per letter from the Attorney General, Assistant Deputy G. Morsey, QC, I took my documents and a reliable witness to the RCMP detachment in Hope, BC. I asked the Constable Jackie Remble to view my documents. As per the Criminal Code of Canada, I would like to lay an information copy enclosed against the Jordans, whose false claim instigated this nightmare. I also gave her the letter, and she left us in the public waiting room to discuss this serious issue in front of others. I offered to leave a copy of my files and pick them up in a couple of days so as they had time to view such a serious issue. She refused to accept them or view them. She called an unidentified male officer, and both told me that we have more important things than perjury and criminal harassment to deal with in Hope. They both told me to hire a lawyer. They would not accept nor view the documents. On March 11th, 2014, more nightmare. My wife's RSPs were seized, plus $6,647.27. This alone is more money than what I'm going to be speaking about with this professional misconduct is coming up. This is much more. The total seized to date by the courts in Jordans and Jay Straith is $11,811 by the court, $12,330 to Jay Straith, $22,000 to the bailiff, Martin Mins, $151 K. Olson's debit card, $3,000 cost to date. And I'm allowed 2/3 of the fees, and that's really low, you guys. Note, the Jordans without the retained lawyer acting also still have the mobile home, and the criminal harassment continues. I believe that Jay Straith is party to this criminal harassment, and I made that very clear to the Law Society. I've been from the top Attorney General's Department to the Police Department, RCMP, and retained a lawyer to lay in information as per the Criminal Code of Canada, my rights. The judges and police refuse any involvement. Their response to me is to hire another lawyer. Can you imagine the embarrassment at my bank when after RSPs are seized, I can't get at my $151 they took it to? I want no more nightmares. Please note, this is irreparable damage. This is severe criminal harassment, you guys. It's all documented, and it has to end. And the Attorney General knows all about it, and I'm going to just show how hire a lawyer works. When this all started with me, way back in 1982, I contacted the Prime Minister, Pierre Trudeau this time, not his son. Pierre's gone now. December the 24th, 1982, I get the first one. On behalf of the Prime Minister, I wish to acknowledge receipt of your correspondence. While we can appreciate the circumstances that prompted you to seek Mr. Trudeau's advice,